Good news for employers, a Texas judge blocks the FTC's ban on non-competes. Hey, I'm Morgan Davis. I'm a health and wellness attorney based in Raleigh, North Carolina, with a focus on cannabis. Let's talk about how to keep your business protected and thriving. So in late August, a federal circuit court judge in Texas, in a case of an employer and revolving around the idea of a non-compete, found that the FTC had significantly overstepped its regulatory authority in issuing the ban it issued in April. So let's back up a little bit. Back in the spring, we talked about the fact that the Federal Trade Commission issued a ban on non-competes nationwide and essentially said that employers had to could not use them moving forward, had to inform current employees who had non-competes that they were no longer valid, and put a huge burden on this, what was a pretty normal contractual relationship between employers and employees in the United States. As of this month, I'm recording this September 19th, that should have gone into effect on September 4th. Due to this judge's ruling, it did not. We'll talk about what that means for you and your business. But for now, what you should understand is that when the Texas judge ruled this, they said that basically the FTC had overstepped its regulatory authority. What the FTC did when they created this ban is they went through a type of rulemaking process that is not really meant for this kind of sweeping change. So when it was challenged in federal court, and this was the third challenge since April, the first challenge was in Pennsylvania. Judge there allowed it through, didn't issue a TRO or a temporary restraining order or an injunction, didn't stop it essentially. It then went through in Florida where a judge narrowed it slightly, but this is the first time in Texas where it's been a complete ban. And that ban is being implemented nationwide because basically it's saying it's unlawful and outside the rulemaking authority. The FTC has responded in saying that it will appeal the judge's ruling. It has not as of September 19th. And it does say that it will continue to enforce it will continue to police and go after non-competes that are challenged in front of it as predatory or otherwise unlawful, as it has always done, on a case-by-case basis. For businesses, I think a lot of businesses are jumping for joy because they don't have to go back and tell all of their existing prior employees under non-competes that they're not valid. They are still valid as of now. And they can continue to use non-competes in negotiations with future employees or current employees. The FTC may appeal the decision. We'll just have to watch over the coming months to see what happens. In the meantime, continue to use non-competes. They are valid.